From the Library of Congress in Washington, D.C.
Good morning. My name is Leon Shosha. Welcome. Please note that the Library of Congress is recording today's program for later web broadcast. And know that comments made this morning do not reflect the opinions of the Library of Congress. As you took your seats this morning, you found a program on your seat with two inserts. The first insert contains the 30 articles of the Universal Declaration of Human Rights. The second insert contains the Friends of the Law Library of Congress insert. This independent nonprofit group has been in existence for over 80 years, helping to support the programs and the services of the Law Library of Congress. Please consider becoming a member of the Friends of the Law Library of Congress. All of the particulars are on that insert, or you can visit the Friends on the web at www.friendsllloc.org. It's now my pleasure to introduce the Law Librarian of Congress, Ms. Roberta Schaefer. Thank you.
Good morning and welcome. As Leon mentioned, I am Roberta Schaefer, the Law Librarian of Congress, and it is my pleasure to be here today to welcome you to the Library of Congress, which I think probably should be renamed the Fortress of Freedom of Thought. And in this fortress there is an incredible arsenal. And this arsenal is comprised of, in my point of view, the only acceptable weapon that humankind should be allowed to make. And these are weapons of multitudes of information. So they are not weapons in any sense of the word of mass destruction, but they are weapons of mass instruction. And these weapons of the human mind sit peaceably next to each other on shelves or in drawers of musical scores or prints and photographs or films, or in the case of the Law Library, over 2.6 million volumes and other forms of material that comprise the legal collections of the Library of Congress. And they sit there on duty, waiting for the serious scholar or the curious citizen to come and use them to enrich the mind and thereby enrich humankind. So it is incredibly appropriate that you are with us today to mark the 59th anniversary of the UN's declaration of December 10th as International Human Rights Day. And we have a program today that really will accentuate how important this day is in the history, in the calendar of mankind. For a number of years, the Law Library has been marking International Human Rights Day, and last year we started a tradition that I believe we will be continuing for the years to come, and we're certainly continuing this year. And that tradition was that we highlighted or identified a group that has a particularly important role to play in human rights. Last year, it was the group known as non-governmental organizations, or NGOs. And this year, as many of you know because you're here, we are highlighting journalists with two wonderful panelists and our own Louis Fisher as the moderator to explore the role of journalists in human rights and in practicing their trade in a time of terrorism. But before turning the program over to Lou and the panelists, I just wanted to say that we all owe a great debt to journalists because in many cases, their willingness to take on the beat of human rights has then created a drumbeat for individuals and governments to follow through and actually initiate change so that the world is a better place and individuals as well as groups of people are safer because journalists, through the weapons of their words and images, brought attention to human rights issues for the world. Now, there are a number of journalists who, unfortunately, have become household words because they have taken incredibly courageous steps in bringing attention to issues of human rights for the world. And among them are Roxana Saberi. We remember her. She was imprisoned in Iran. Xiao Tou, who was imprisoned in China. In North Korea, President Clinton had to go to bring his weight of authority to have Yuna Lee and Laura Ling released from prison. And of course, Daniel Pearl, whose beat was covering issues in Pakistan, actually gave up life in order to pursue his trade. So we hope that that will never be the case of journalists, but we want to have this program today to enlighten all of us so that we do not forget these phenomenal heroes who have done so much for the cause, and to learn how we as citizens, lawyers, and librarians can play a greater role in assuring that we don't mark International Human Rights Day, but in years to come, we celebrate it. And without further ado, I turn the program over to Louis Fisher. Thank you again for being here today.
Thank you all. The reason we picked this topic of free press and age of terrorism is there's a large theme in American history, I think in every country, as to what happens in a time of war or a time of terrorism. One position is that free press and free speech declines. Whatever you had in time of peace, you have less of in time of war. That was the position that Justice Oliver Wendell Holmes took in the World War I period initially. But he, on the other side, was met by professor from Harvard Law School, Zachariah Chafee, who said, no, it's the opposite in time of war and terrorism. Free press and free speech has to be at its zenith because government can make the biggest mistakes, and you have to have that check. So we have two wonderful speakers here today. Lucy Dalglish will be talking about free press from mostly a domestic U.S. standpoint. And we have Clothilde Le Coz speaking from international standpoint. So that's perfect for the law library. We love to have things both domestic and international and comparative. So I'm going to start first with Lucy. I thought each speaker could have about 20 minutes to get some comments out, and then we'll have plenty of time for audience comments. So Lucy.
It's a pleasure to be here. Thank you very much. For those of you who are not acquainted with the Reporters Committee, we are a 40-year-old organization based in Arlington that does legal defense and advocacy work for any journalist working in the United States. That could be a foreign journalist who runs into trouble here. We try to work very closely with other international journalism groups so that if anyone has trouble internationally, we do a lot of referring back and forth. And then on issues of obvious interest to all of us, we try to work together whenever possible. I will start out by saying I have the luxury of working with U.S. law. I do a lot of work. We bring in a lot of foreign journalists into our office. We'll have roundtables, educate them a little bit. The State Department will bring them in. We'll educate them a little bit about what's going on in the U.S., and there's never been a time when I've not been incredibly humbled because these folks around the world who are trying to get information to their readers and viewers and listeners run such incredible risks that you very rarely have to worry about here in the United States. So if it sounds like I'm whining and moaning about the way things may or may not be in the United States, please be assured that I understand that by comparison, I'm operating in a dream world. I'd like to talk about two basic issues today, or two topic areas. First of all, I'd like to talk about a recent conference that I attended in Vienna, where we came up with something. I was one of the drafters of something called the Vienna Declaration on Terrorism, Media, and the Law. And it was following a 3-day conference with international journalists, human rights leaders, politicians from all over the world, and it was a very interesting experience. And then I would like to close with my remarks with a little bit of some observations about why the way the United States handles prior restraints, the First Amendment, confidential sources, things like that, why it is so completely different in approach from the way it is handled almost everywhere else in the world. So to start off with, it was a very interesting conference in Vienna. We had folks from Pakistan, Saudi Arabia, Russia. We had the chief FLAC, the chief PR guy from Moscow, who was there. And it was a very fascinating few days. We came up with some conclusions that basically jibe with what Roberta and Louis have said, that in times of war, in times of great international stress, more communication is better than less. Basically, just to refresh your memory, Article 19 of the Uniform Declaration of Human Rights says that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Now, we obviously recognize that security is essential to safeguarding democracy and all other human rights. And furthermore, Article 3 of that Universal Declaration guarantees the rights of liberty, life, liberty, and the security of person, which is, of course, related to wider security concerns. But at the same time, an important objective of many of those committing acts of terrorism is to undermine democracy and weaken respect for human rights. Journalists reporting on terrorism sometimes risk being attacked, taken hostage, or even killed. To respond to terror by unduly restricting rights, including the right to freedom of expression, would be to play into the hands of terrorists. The folks at the conference concluded that effective security and respect for freedom of expression are not incompatible, but rather complementary. Indeed, it was the view of those at the conference that the free flow of information and ideas is an important antidote to terrorist ideologies, and that a free media is indispensable to achieving this. Terrorism thrives where secrecy and rumor mongering prevail. The declaration, I'll just go briefly through the major points of the declaration. A free and independent media, including new media, can play an indispensable role in holding those wielding power to account. A robust media, able to exert an effective watchdog role over security policies and bodies, and thereby help prevent abuse and wrongdoing, is key to combating terrorism. No restrictions should be imposed on the right to freedom of expression, including to safeguard security, that do not meet international law standards. And reporting on terrorism poses special challenges, and the media should always strive to do so professionally and in accordance with ethical standards, including the principle that I think we recognize here in the United States of minimizing harm to those who are being covered. So the declaration goes like this: everyone has the right to access diverse, uncensored sources of information. States should create an environment that encourages the development of a diverse, pluralistic media. Media freedom, including editorial independence, should be respected by states and intergovernmental organizations. Specific obligations should not be imposed on media outlets in the pursuit of counterterrorism. In addition, the media should be free to report on terrorism, including terrorist acts and ideology, as long as this does not constitute intentional incitement to terrorism. This was actually a very controversial prong. If you talk to some reporters and some public officials in certain parts of the world, Pakistan comes to mind, they will tell you just merely reporting on these issues is by de facto incitement to terrorism. But such reporting should not be penalized, we concluded, as radicalizing potential terrorists or under other vague and unduly broad grounds, such as glorifying, justifying, or promoting terrorism or extremism. And coming from the United States, the mindset that you are glorifying terrorism by reporting on terrorism is completely foreign to me. But there are certain parts of the world where that is exactly what the mindset is. In addition, the rights of the media to report on violations of human rights and on the infringement of civil liberties should be respected. Voluntary self-regulation of the media is an important and appropriate means of promoting professionalism and high standards of journalism. States should respect the right of the media to engage in self-regulation, which may include establishing standards of practice and other media accountability systems. As you might imagine, those of us who are from the United States were horrified by that one, where we believe that the First Amendment prohibits any regulation of the media. In addition, it says policies and laws adopted with a view to combating terrorism should be consistent with international and constitutional standards, including freedom of expression and of the media. States of emergency should not be declared outside of situations that threaten the life of the nation. Any limitations on rights during emergencies, including the right of freedom of expression and of the media, should be limited in ways and duration that are strictly required by the situation. No state or intergovernmental organization should seek to take control over a private or public media outlet, including during an emergency or terrorist threat. States and intergovernmental organizations should recognize and respect the right of media workers and media outlets to protect the identity of their confidential sources of information, which, as I will mention in a few minutes, is actually more controversial here in the United States than anywhere else in the world. The right to access of information from public bodies, both national and international, as well as private bodies undertaking public functions, should be recognized in law and respected in practice through freedom of information laws in accordance with international standards. Public bodies should, in particular, avoid overbroad national security exceptions to the right to information. And finally, enforcement of counterterrorism laws should never be arbitrary or conducted in bad faith, and should always be subject to independent judicial oversight. It was an interesting experience. There are already 30-some international organizations that have signed on to this declaration. For me, the most interesting discussion, and the one that became most heated and most controversial and resulted in an entire prong of the declaration to come out, was there was a sizable portion of the audience in Vienna who were adamantly opposed to any prong saying that you should be able to freely report on religion. In certain parts of the world, you do not report on religion, period. Which, of course, here in the United States is also a foreign notion to us. It was interesting to me, as a lawyer and former reporter, the way most other nations handle threats to national security when information is reported by the media. In the United States, we take a very interesting and different approach to regulation. In most of the rest of the world, if a reporter gets access to information and wants to publish a story, the response of the government, if they believe there is a threat, is to shut down the story, shut down the news organization, just censor it. It protects everybody from getting all of this information. Now, many countries make a great big show of the fact that, yes, but we protect the right of our journalists to protect their confidential sources. In Sweden, for example, it is illegal for a reporter to identify a confidential source. It's a crime. There are many other countries around the world that provide great protection for reporters to protect confidential sources. But if they don't like what you're about to report, or if you've been leaked some information from a confidential source, they'll just shut down the story. That happens everywhere except the United States, because as you know, there's a case, two cases out there, Near versus Minnesota back in the 30s, and the Pentagon Papers case from the 1970s, where the U.S. Supreme Court has said, we will only censor a story or issue what we call in this country a prior restraint on a story if there is an incredible threat to the security of a nation. And as a result, the United States Supreme Court has never upheld a prior restraint on the media in this country. It's a system that works very, very well. That is balanced by a system where the federal government in particular has never recognized an official right for reporters to protect their confidential sources. So if a reporter is leaked information, we call it, of course, a confidential source of information. The government usually refers to these people as leakers. We think they're sources. The government thinks they're leakers. So what they will do instead is they will let the information be published because they know they're not going to be able to get a prior restraint on it in most situations. But then they will go through a process where they will try to figure out who leaked it. They will try to criminally prosecute, if they can, the leaker, or at least get them fired. And the way to do this is to subpoena a reporter and find out who that confidential source was. In 1972, in a case called Brandsburg versus Hayes, the media lost a challenge under the Constitution, under the First Amendment. In a three-part case, there were three reporters who were trying to keep information confidential, and the Supreme Court said there is no First Amendment right for the media to do this. We recognize that if states or the Congress want to pass statutes protecting this right, we'll go along with it. It's a very complicated, as you know, American common law, American constitutional law, and American statutory law. It's very, very complicated, and the right of reporters to protect their confidential sources varies by state, varies between the federal and the state governments. It varies versus civil versus criminal. The law is all over the place. But you may have noticed that we are currently trying to get a federal shield law passed through Congress. We've been trying to do this. This was the issue my organization was developed on. We were founded on this issue in 1970 because of those three cases in Brandsburg versus Hayes. We're still out there fighting for this. And actually, starting at 10 o'clock this morning, Senators Leahy, Schumer, and Specter are going to once again go up against Senators Sessions and Kyle, trying to get federal shield law passed through the Senate Judiciary Committee. If it does, it will only be a qualified privilege. The government will still be able to get the identities legally of confidential sources under certain circumstances, particularly if national security is implicated. But that is a very different framework. The law works very differently. So I always get a charge out of these folks internationally when they say, well, we can't believe in the United States you don't protect your confidential sources. I go, yeah, you guys would just shut down the story. It would never get out there. It's a very different way of looking at the problem. It's a very different way of handling the problem. I think all in all, the way the framework has worked over the years in the United States has actually unquestionably led to more information actually reaching the public. And I would like to take this opportunity to formally introduce Clothilde to you. She's been here about 4 months now. Reporters Sans Frontières, or Reporters Without Borders, is very active internationally, and they are one of the two groups that I go to if I have a question about anything happening. I hope you're enjoying your time in the United States so far. Her predecessor was also named Lucy. So if we were on the same program, it was very unusual to have Lucy and Lucy. But she always pronounced it, it's always sounded so much better. It was Lucy. A much fancier name. Thank you.
Thank you. So my name is not Lucy, my name is Clothilde, even harder. I'm very honored to be here today, and thank you very much for your introduction. Actually, thank you also for the work you're doing in the US, because it's very important, and Reporters Without Borders can't handle all the US together. It's not possible. If you don't know Reporters Without Borders, the headquarters are based in Paris, and there are about 30 people working there, and 6 reporters are getting information from our correspondents all over the world. We have more than 140 correspondents who are helping us. And eventually, those correspondents are often harassed and threatened because they are working for us. Some of them are accused of terrorism by their government because they are leaking information. And so we're trying to help and to protect them, not only the correspondents, but journalists worldwide. Generally, in terms of free press and terrorism, generally, Reporters Without Borders believes truly that a journalist has the right to investigate in all affairs possible, even those linked to terrorism, and even more to those ones, because it's in those times that we need information and that people need information to know exactly what's going on. The limit is when you release an information and it puts somebody's life in danger. That's the only limit that we put to that right to investigate. Actually, today, while we are speaking, there is J.S. Tisanayagam, who is in Sri Lanka, and who is the first case known as a reporter accused under an anti-terrorism law in a democratic country. Right now, there is a hearing at the Congress on Sri Lanka and on his case. He has been arrested on the 31st of August 2009 under that terrorist law. What is really interesting in that case is that he was convicted under 3 charges. One was writing an article for a magazine. The other one was writing an article for an online magazine that he founded. And the other one was to have received funds from a terrorist organization, implying LTTE. And during the trial, the third charge was totally ignored. The government has no proof that that journalist has received funds from the LTTE or any other organization to pay his magazine and his website. So what Sri Lanka just did in August is make writing as an act of terrorism, because they have no proof that there is a money exchange or money evidence. What I did, knowing that I would be here this morning, is I asked all the team in Paris to send me examples of cases that they have worldwide and journalists convicted under terrorism law or accused of terrorism. Actually, the something that is also important is the role of the internet and how internet can be conveyed as a terroristic tool. And for example, in Syria, in 2 years ago in Syria, Facebook was blocked because the government considered that Israeli spies would be infiltrating the internet and the websites, and that was considered as terrorism. So they just shut down the website. In Ethiopia, 3 months ago, the Ethiopian government gave 2 journalists 1-year jail sentences for dissemination of false information. And that's something really important because the journalists are never, except Tisanayagam in Sri Lanka, but the journalists are never convicted under terrorism. They are not accused of terrorism. They are accused of disseminating false information or convicted rumors or those kind of charges that is not saying really and directly that they are terrorists. In Ethiopia, what happened is that the law states whoever writes, edits, prints, publishes, disseminates any promotional statement encouraging, supporting, or advancing terrorist acts is punishable 10 to 20 years rigorous imprisonment. And of course, what is meant by terrorist act is not defined by law. And that's something that we find in many countries, that a journalist is accused of a terrorist act, But then when you are looking for the definition of the terrorist act, you don't find it. So it's up to the government to set up what is a terrorist act. And so that happened in Ethiopia. That happened also in Turkey, where in Turkey they have an incredible legal arsenal to accuse journalists and put them in jail. Actually, since 2005, more than 200 intellectuals, journalists, writers, even politicians, have been sued by the Turkish government because of what they are writing or saying or publishing. So in Turkey, an anti-terror law has been used to prosecute journalists, and especially the one who are covering the minorities issue, or the Kurdish demonstration and military operations. For example, there is a journalist detained in Turkey since June 2006 because he was accusing of collaborating with the PKK. And actually, what he did is, like, what happened is that a PKK activist told that that journalist was supplying the members of that party with a laptop computer and 10 CDs. And so he was convicted under that law, under that anti-terrorist law. And he's still in prison since 2006. There is also another interesting initiative in Pakistan. In Pakistan, the government decided to regulate the internet because of the terrorist acts that could be online. And actually, it was on November 2008. The president adopted a law who introduced severe penalties for spamming, hacking, and blogging. And spamming and hacking could be considered in the law as act of terrorism. Blogging, it's another issue. But actually, what sounds funny is that the law says the expression terroristic intent means to act with the purpose to alarm, frighten, disrupt, harm, damage, or carry out an act of violence against any segment of the population, the government, or entity associated therewith. And in fact, that law was adopted because the authorities have always defended it by referring to what happened with Daniel Pearl's abductors. They consider that the internet has to be regulated because the murderers exchanged emails in order to kill Daniel Pearl. But they never, what never appears in the law is that they actually murdered him. So they are trying to prevent the exchange of emails, but not to punish the fact that they murdered Daniel Pearl. So that is in Pakistan, that is really something very sensitive at the moment. And still in that country, in Pakistan, there are about minorities. There are Baloch journalists. So Balochistan is covering about 50, like half of the country, are Balochistan people. And they are very often, journalists are very often arrested for disturbing public order. And that's also something that is hiding the fact that they are considered as terrorists. Because as I said, you won't find a journalist except the Sri Lankan convicted as, and namely, terrorist. Regarding the fact, like how we can protect the sources or having media shield law. 2 years ago, our organization called for a European level of protection of sources because I mean, I'm speaking about Africa, about Pakistan, and about all those countries where there are some repressive regimes who are really want to convict journalists under any law possible, and the terrorists more used, but any law possible in order just to silence them, and it's a way to silence the critics. But in Europe, if that doesn't happen, there are still lots of harassment of journalists. And actually, this year, we released a World Press Freedom Index. And so it's something we release every year, and we are ranking countries. And what we saw this year is that Europe has really shrunk in the rankings. And all European countries, Western European countries, France, Italy, for example, Spain too, because there is harassments against journalists who don't disclose their sources. So what we did 2 years ago is we called for a European level of protecting the sources, and it didn't really happen. That's why we signed the Vienna Declaration, and it's something really important to our organization, but also to the journalists, that their sources can be protected and that they won't be harassed, because they want to have the right to protect these people. Actually, the main threat in Europe is legislation. So, and national security is coming up. It's not as important as the US, but it's coming up. And for example, if you see what's going on in Italy, Mr. Berlusconi just have the hand on the media because he decided that it is better for him to have all those medias and to have one message going out of the TV channels and the newspapers. And it's to protect national security, because it's very important that he is always referring to gangs and to the mafia. So it's a way to protect people from the mafia and the bad information who could come from journalists. And it's also a way, and that new legislation thing in Europe, where all the countries are trying to adopt new laws for medias, is also a way to tell journalists how they have to do their work. They have to obey a strict frame and not to go out of that frame. Regarding, as we are a French organization and a European organization at first, regarding the U.S. position, as Lucy was saying, it's true that it's very different, and the U.S. view of protecting sources is very different from everywhere in the world. What we really hope is that this law will pass, and that the federal shield law will pass, because it already has, there were stronger arguments before, even to protect the journalists and to protect the sources, and it has already been undermined. So this version has really has to pass. I know that I've been like quite quick an overview of lots of different countries, and I will stop there because I am really waiting for your questions, and if you have specific ones on specific issues or countries. What I would like to do to end that speech is today, so it's the International Human Rights Day, and we are calling for the release of that Sri Lankan journalist, Tisana Yagam, who is the first journalist convicted as a terrorist under an anti-terrorist law in a democratic country. Thank you very much.
I have a question for both speakers, and then we'll turn it over to the audience. My question has to do with what role the courts should play, both in the United States and abroad. And there are at least two questions, whether courts have competence to handle national security questions? And secondly, if they do take a case, what should the standard be in terms of deferring to executive branch statements? On competence, I've been on panels before with federal appellate judges, and they will tell the audience that we have no competence in areas of war and national security, and with my usual subtlety, I would say to the audience, if they knew more about their own institution, they wouldn't say that, because the Supreme Court has been involved with war power cases from 1800 at least through the Korean War. And it's quite true during the Vietnam period, courts were ducking those cases left and right. And you see the courts back again after 9/11 involved in national security matters. So that's the area of competence. These are legal constitutional questions that the courts can handle. They do have jurisdiction, they do have competence. Lucy mentioned the Pentagon Papers case. During oral argument, the Solicitor General Erwin Griswold told the Supreme Court that if the study by the Pentagon ever got into the newspapers, there would be a grave damage to national security and it would result in deaths. And later in an op-ed piece for the Washington Post, Griswold said there was nothing like that ever happened, and in fact, when people withhold information, it's usually to avoid embarrassment by the executive branch. So that's one issue. Also, in the last couple of years, the House and the Senate here have been involved with the state secrets bill that when private citizens go to court, the executive branch will intervene and say the case cannot move forward because to do so would risk the disclosure of information damaging to national security. And there you get into the issue of deference again, because some courts have held, well, the Supreme Court held in 1953 that in some situations the case not only cannot move, but that the court itself couldn't even look at the evidence. They would just have to accept what the executive branch said. So the current Senate bill has a standard of deference. Federal judges would defer to statements made by the executive branch, whereas the House, I would say correctly, does not have a deference standard. They have a respect standard. The judge would respect both sides, which should be the case on a case, and then it depends on what evidence is being brought forward. So I'll start with Lucy, just on what your thoughts are, both in this country and abroad, if you like, on what roles should judges play on these cases.
Do I need to do it from there to be picked up?
Leon, speak up here.
We can do it from here. Everybody can hear me? Okay. Well, those are very interesting questions, and I'm not an expert internationally, but I think in general, I've always believed that judges should judge. That's why we make them judges. And that it's rather insulting to the concept of balance of power, separation of powers, to suggest that judges have no role in these questions. I can tell you it was very, very interesting. I've been involved in the most recent effort to get a federal shield law. I've been involved in that for about 6 years now. And of course, the biggest obstacle to it really has been the Justice Department. And they believe, and those of you who are former prosecutors will understand what I'm saying with this, particularly in the grand jury context, they believe that it is their exclusive right for the executive branch to be able to present whatever evidence they want to a grand jury, and that the judiciary has no role in that whatsoever. So while the national security arguments against the shield law have been popping up here and there, that's really been coming from the Defense Department, the CIA, the State Department, all the other agencies. From the Justice Department, it is, how dare you take this exclusive right away from us? Now, of course, we have privileges for other types of people in society. We have privileges for doctors. We have privileges for clergy. We have the spousal privilege. We even have a psychotherapist privilege that is recognized, and judges are expected and very ably evaluate those arguments and privileges every day. But when you talk to the folks at the Justice Department, they'll say, you don't understand what you are asking us to do here. And I'm like, yeah, I do. You know, sure I do. I get it, yeah. And I'm humbly asking you, I understand we're asking you to give up a power here. But a lot of the fine-tuning, now that we actually have some shield law legislation pending, a lot of the fine-tuning that has been going on has to do with the degree of deference that a judge has to grant the executive branch when they go in. The way it works is you subpoena a reporter for the identity of a source. The reporter then will typically go in and make a motion to quash, and they will present evidence. And of course, the reporter is almost always flying blind because they don't know what the government has. The government's certainly not going to tell them what they've got in front of the grand jury. So you really don't have much to work with to figure out why it is they want your source in many circumstances. Sometimes you kind of get it, you know. In some of these cases, it's pretty obvious who they want and why they want it. So the fine-tuning has been, we were joking a little earlier, if Senator Kyle had his way, the language would read, you would have to give utmost deference to the government when they tell you national security or some other compelling interest is implicated. He doesn't want a judge making that decision. I think we're going to get, I think this is actually a red herring, because I cannot imagine a federal judge, once a prosecutor goes in and says, Your Honor, national security is implicated, there's not a federal judge out there who's not going to defer to them or give them the benefit of the doubt. And for that reason, the thumb is clearly going to be on the scale in favor of the government. On the state secrets privilege, this has been mind-boggling. I didn't even know anything such as the state secrets privilege existed until I moved to Washington. You know that between 1953 and 2001, in all that time, the state secrets privilege had been invoked fewer than 20 times. In all that time. Between 2001 and 2008, I think the number is something like 25 additional cases. This is where the government goes in and says, you know, we may or may not have done something, a tort, you name it. We may or may not be responsible for something bad happening. But you know what? If we litigate this, so much information is going to be revealed. Judge, you just have to throw out the case. And they were throwing these cases out left and right. Now, you know that the Obama administration came in and said, we're going to change the standards. We still have not seen, however, any concrete evidence that they are actually doing more than talking about it. A lot of the cases that the Bush administration moved to get thrown out are still pending, and the Obama administration declined to withdraw that privilege. I think it's also really insulting to think that judges cannot make those judgments. There have been a couple of cases out there that I'm aware of. One was out in California. I think one was in the Northern District of Virginia, or Eastern District of Virginia, where they actually said, you know what, I'm not buying this. You got to do better than that. And they made him at least go back to the drawing board and bring further evidence. And of course, you're just really flying blind if you're the plaintiff trying to recover something. Then, of course, also years, decades later, we're finding out that some of these earlier cases, for example, the Reynolds case. The Reynolds case was the first one in 1953 where this privilege was recognized. The Reynolds family, the father of the family and some others had gone down in an airplane that was doing some Defense Department experimental whatever. It turns out that the family, once they sued, the case was kicked out. 30 years later, they found out that the government lied. Surprise, surprise. That, in fact, there wasn't any big secret reason why they couldn't litigate this case. They were just going to be embarrassed. And of course, at that point, there was nothing. The family tried to reinstitute the case and were unsuccessful. So I think We have judges for a reason. I think they have a very, for the most part, they're very smart people, and we need to rely on them more than what the executive branch in particular thinks we should be relying on them for.
From a broader perspective, I would say that the judges are judging in most of the country, but under the laws that are already there. So if you take the example of Egypt, it's been more than 20 years that Egyptians are living under a state emergency law. And most of the new generation doesn't even know why it's there, and they don't understand anything about the fact that they don't have the right to gather, they don't have the right to protest, and they don't have the right to cover religious issue when there are reporters or it's very sensitive. And they have discovered that great power of the internet and are trying to do that online. They are gathering online, they are speaking out online, and it's really incredible what they do. But judges, I mean, when one of these demonstrator or journalists or bloggers, because there are lots of bloggers. Egypt is one of the most active, has one of the most active blogosphere. Once they are arrested, they are tried under that state of emergency law, and you can get in jail for 20 years if you are criticizing the government. And actually, there is already a student who just criticized his university online, who has been accused of criticizing the President Mubarak, and who is now in jail and has been condemned to 5 years in jail because of what he posted on his website. And sometimes in other countries, it's not even the judges that are judging, but administration authorities. And it's the case in Turkey when they want to shut down a newspaper, for example. They don't have to have a trial with judges. It can be done by an administrative authority. And regarding the state secret issue, we've got an example in France a year ago, or a year and a half. His name is Jérôme Dasquier, and he was a reporter that was working for a newspaper, and he decided to become a freelancer. And so he started his own website, and he released an information about state secret, and that he had from his former sources when he was reporting for that newspaper. He was held for 2 days and interrogated by the government on his activities and why he was releasing that. That's an example. But as you said, Lucy, most of the time, the government, they don't even try to know why the information is published. It doesn't have to come out. It can't come out. It can't be published. So in China, most of the journalists and dissidents are in prison because they released information coming from abroad or going abroad. And that's exactly what happened during the Sichuan earthquake. And for example, when human rights activists and also a reporter, he is both, just answered to BBC and to questions of the BBC. And he is in prison because he is accused of releasing state secrets abroad, because it was broadcasted here and in the UK. That's very common in China. And right now in Iran, we have the same kind of phenomenon. You are aware of what's going on in Iran right now. And the protesters are now mostly students, because the reporters are fleeing the country, and the bloggers too, because they know that they will be either jailed or threatened or tortured. So since the election, 50 journalists have fled the country and are now in Turkey or in Kurdistan. And as the government can't find them, they're just threatening the families and the friends who are staying in the country. And that's all because the photographers, that mostly photographers, because they have proof, they have images of what was happening there during the election and after. So what happens is that they are accused by that government to release state secret and to attempt to the Islamic orientation ministry that they have. And that's a very serious issue. And most of them can't go back to the country. It's not possible. So one of the role of our organization is, for example, to find visas for them and to find them a place to stay. But that's another question. But they are really threatened because they have proof of what happened, and that obviously Ahmadinejad is not happy with that. And they are accused of releasing state secrets.
This kind of brings up an interesting issue, I think, about technology, because 20 years ago, almost 20 years ago, when I was the national and foreign editor at my newspaper, to get images and to get information out, you really had to rely often, particularly in Iran and Iraq and everything, for a government line to get the information out, unless you had one of those very, very expensive satellite phones. And I remember a photographer friend of mine saying, you know, he wasn't too worried about the fact that in the Operation Desert Storm, that they were shutting down everything he was trying to send back. He'd have to go through an Army censor to send pictures back. And he says, you know what, in a few years this isn't going to matter. These people are going to have no control over us. I'm going to be popping out my little suitcase and uploading and you name it. And of course, he was right. I don't know if anybody else has been listening to, I listen to the CBS radio a lot. I love radio news. I just love it. And in the last several weeks out of Iran, I've been hearing like Fareed Zakaria, you know, and they preface the stories out of Iran saying nobody's allowed to report in Iran. So from his listening post outside of Iran, they go to great trouble to explain that he's not there. I don't know what a listening post is. I have a hunch they have people with Twitter feeds, cell phone cameras, all of these things, and technology is playing an incredible role in getting information out of these places. Now, Fareed's probably never going back to Iran. You know, I don't think they'll ever let him in, but it has made an incredible difference in the amount of information that's coming through.
Okay, I'm going to turn to the audience. Just 2 points about state secrets. The government will go into court and tell a judge that this particular information, if there's public disclosure, would cause great damage to national security, and no one is talking about public disclosure. No one in the case is talking about giving that information to a newspaper and putting it in the New York Times. And as Lucy mentioned, one issue is whether that information, secret information, should be given to the judge to be read in chambers. Can you trust the judge to do that? And the second issue is whether you could give that information to the plaintiffs' lawyers on the other side. And there's a case in California, the El Haramain case. It's one of the few remaining NSA cases left. Judge Vaughn Walker ordered the Justice Department to give clearances to 2 lawyers for the private party. And when the Justice Department started to do that, the NSA intervened to say that if you give clearance to those 2 attorneys, they still don't have a need to know. You have 2 steps. You get clearance, and then the second is need to know. So here you have a party to the case, NSA, saying that they have no need to know. I have no idea where Judge Walker is going on that, but that's quite a story.
The judges are clearly frustrated by all of this because they're told they don't have a right. There was an interesting case, some of you might remember, and it was an interesting intersection between state secrets and reporters' privilege and a huge national story, and that was the anthrax story. When the story came out on live national television, Attorney General Ashcroft says that this man, Stephen Hatfill, an Army scientist, was a person of interest in the anthrax investigation. Of course, we all know ultimately that was wrong. But Mr. Hatfill, one of the first things he did was file a Privacy Act lawsuit against the government. He was pretty sure, obviously, it was violated. I mean, John Ashcroft himself went on national television. But there were reporters that were reporting this and other people going and confirming it, and so they're writing these stories. Mr. Hatfill sues the government. They get in front of Judge Walton. The FBI and the Justice Department go in and immediately argue, Your Honor, this is so sensitive. This is an ongoing investigation. National security is threatened. State secrets. They had a whole laundry list of this stuff. You have to throw out this lawsuit. Judge Walton, on his own, said, okay, I buy that. Therefore, Mr. Hatfill, since I'm not going to make the FBI respond to any interrogatories, take any depositions or anything, Mr. Hatfill, I am ordering you to go to like these 16 media entities and find out who the leaker was, so that the FBI doesn't have to respond to any of this at all. And we're going, hello? So this was just totally sua sponte. We'd never seen that happen before. So this began about 4 years of absolute nonsense that resulted ultimately in a reporter for USA Today, Toni Losi, who couldn't remember her sources specifically. She got some of them to say, one of them, by the way, was Eric Holder, who was deposed. He said, yeah, I told a lot of reporters about Stephen Hatfill. Yeah, you bet. Anyway, there were a lot of people doing all of this, and it was this bizarre intersection that we got to that point much faster because Judge Walton said, okay, I buy the state secrets argument, go talk to the reporters. And of course, ultimately then, the FBI got a little bit more information. The reporters said, no, go back. And the FBI ultimately did litigate the case, or the Justice Department did litigate the case. But I got to tell you, the media lawyers who came out of that, you know, when we heard about that particular thing and the newsrooms went, what just happened to us? How in the world did that just happen? We went from state secret to, it was unprecedented.
There's one other encouraging sign, then I'll turn it to the audience. There's a Binyam Mohammed case. This is a rendition case of someone who was picked up and moved from country to country and claims that he was abused and tortured, and was taken to Guantanamo and then was released from Guantanamo, went back to London, where he's a citizen and is suing. And it was in British court, and decision after decision, the United States told Great Britain that if you release that information that Binyam Mohammed once released, the threat was from the United States to Great Britain that we won't cooperate with you on anti-terrorism. We will not share anything with you in the future. And the court in London deferred to the United States, deferred to its own foreign secretary, and went through about 4 drafts of its decision. And the 5th draft, it said, this is nonsense. I mean, no side has given us any information, and we're releasing this information. So that's, after a while, judges can get frustrated. So questions from you, if you would identify yourself in the back, please.
Yeah, I can see what
you identify yourself, please.
Oh, excuse me, I'm Mike Jones, I'm a retired actor.
Okay.
You're talking about restriction of the press once they've decided to make something or try to make something public knowledge. I'm always disturbed by the freedom of the press to make a decision as to whether to bring something into the public's view.
Mm-hmm.
And I'm sure you're both aware, all three of you, of things, items that go within the press that everybody within the press somehow decides not to bring to the public.
Right.
And I mean, I could
Mm-hmm.
cite several examples of that, but are either of you concerned about that issue? Do you try to make the press let those ideas bubble up? And why do they have that discretion?
Why does the media have the discretion?
Yes, why do reporters have the discretion to suppress the stories that may ultimately lead to a terrorist being identified or other things too.
I want to make sure I understand the question.
I'll give you some examples.
Yeah, please, that would help.
Guantanamo.
Right?
The press was always saying, well, Guantanamo is bad, we're holding these people. They created the idea in the minds of the people, I think, that Guantanamo was completely terrible. They did not have the articles showing the other side of the awful terrorists that were being held there and why we were holding them. So that they suppressed the balanced view.
Yeah.
I'll give you another view.
Mm-hmm.
The press is very much on the side, seemingly, on global warming, that global warming exists and human beings caused it. They do not present a balanced view of the other side, except for these emails. So they have decided that these scientists are correct,
Mm-hmm.
and that that's going to sell papers. And they don't give the other side, which is, it's a very valid argument.
You know, I don't know much about, I mean, I am fairly well versed in what was going on in Guantanamo, and I can tell you that having been involved in several legal actions, trying to figure out who in the world those people are, where they came from, what they are accused of, what they are suspected to have done, my perspective is, when we figured that out, we reported it, and there is no question some of those folks are really bad actors. Absolutely no question. But the cloak of silence down there was so intense. So intense. It was a couple of years before any reporters were even allowed to go down there. And once there were a couple of appeals about, you know, those review panels. I have several, Tony Losi, Nick Lewis from the New York Times, several people from the AP. They've had somebody down there pretty much they had somebody down there nonstop for years. You couldn't get anywhere near those people. We sued for the names of the detainees, couldn't get it. Sued for any information whatsoever. Now, we know, yeah, some of these people are probably really bad folks. Some of them, when you get information from their families and you piece it together, some of it trickles out. But I got to tell you, the lockdown on that information was unbelievable. And it still is. It's getting better. Some of these review panels did allow some of this information to trickle out. But I completely agree with you. Some of these people were horrible, horrible human beings. And, you know, and I think that we're catching up with that.
It's hard for me to believe that a number of people in the press didn't know that information.
There are about 800 who were taken there. We're down to a little over 200 now. So
Mm-hmm.
a lot of the people who were taken, there was a concern, and the press picked it up about a lot of these people were being picked up not
Mm-hmm.
because of anything they did, but because of a bounty system where you could get $5,000 or $20,000
Mm-hmm.
for identifying someone as Al Qaeda or Taliban. But I think the executive branch also has admitted that it did a poor job on getting the story out, even when the story would have been good for the executive branch. It didn't do a good job.
You know, I can't. That's my best shot at explaining that one. The global warming thing. I got to tell you, maybe it's because I'm a news geek, because I'm reading things all over the place. But I have heard the other side. I totally read about that. I just do. I know that there's a dispute. I know that there are some scientists that other scientists are discrediting.
You know, that's not publicized in the story of global warming.
Other questions, please? Clothilde, did you have any comments on that last one?
Actually, about Guantanamo and global warming, I can't I can't really talk about that. I don't know if those are the issues you are interested in, but I can talk about the discretion of reporters and the fact that Reporters Without Borders now is trying to get a sense, something that would be measurable, of self-censorship, because it's something really important among the reporters, and not only in countries where you can't speak, because most of the time in the country when you don't have the right to speak, it's the country where you speak the most. And to come back to China, they don't have the right to express themselves. And for example, the story of the tainted milk it was retained by the Chinese reporter for 4 months before making it public by a foreigner reporter, because that reporter, the Chinese one, couldn't have the right and didn't have the right to publish it. So it means that there were 4 months where people get contaminated and nobody talked about it in China. It wasn't possible. So that's something we are trying to figure out, how reporters are self-censoring and why are the reasons, if it's governmental or if they really don't want to do it, if it's state secret. And those are very interesting issues, but it's hard to have representative feedback of what's going on worldwide.
Got a question here? Go ahead.
Yes, I'm Anshel from the Asian Division. Since we're talking about the time of terrorism, I can't help to bring up the Hamas and Al-Qaeda. The advantage of these terrorist groups is that they are beyond borders, they're beyond any state government, so they act freely, particularly on the internet, and they recruit aggressively on the internet. But Hamas is different because they actually have a base in Gaza. So my question actually is, maybe either one of you can help me. I just wanted to know more about how the Palestinian Authority over there, towards their attitude and their regulations, if any, towards the cyber dissidents, particularly on the internet.
You would know that better than I.
I fear I would be a mistake by answering that question. So what I will do is, getting back to you on that question, be sure that I will do it today, and that I will ask the researcher in the Middle East section in Paris to help to answer that question, because it's regarding the internet. It's they are recruiting online, but in many countries their websites are not accessible. So they have other means. They don't have only the online means. And I think people talking to people is very helpful. And the internet is helping, to have a broader audience. But what is important in that kind of recruitment is that the audience is talking to each other, and it works like that. So I will go back to you on that question. I'll take it.
I'm more interested in those dissidents that are against those this pretty much is sort of like a government or a party organized terrorist activities.
Lucy, anything from you?
No, I really don't know much of anything about how Hamas is organized.
Other questions? Please.
Hi, I'm Connie Johnson from the Law Library staff. I was interested in the part of the Vienna document that you were talking about that you said kind of was counterintuitive for you, or not comfortable for you, about countries setting up some sort of standards that journalists would have to meet. And I'm wondering, I was just sort of thinking about the role of radio journalism in something like the Rwanda situation, where one could argue, if one wanted to argue for those regulations, that the media there whipped up anti-ethnic group feeling against one group to attack another. And would some sort of responsibility standards have been helpful in any sort of situation like that?
I think responsibility standards are helpful for everybody. The question is, are they enforceable by the government? And of course, here in the United States, there are a number of professional journalism organizations that have very widely distributed and adhered to codes of ethics. The most widely used one is sponsored by the Society of Professional Journalists. It's almost 100 years old. It basically has 3 major tenets. One is speak the truth. The other is act independently, in other words, without interference from other institutional folks, and minimize harm. And there are other things in there under those prongs that flesh it out. But That's basically where we get this notion of a responsible press in this country. I think those standards work very well, and it is largely, I think, part of our culture that those are recognized principles. Under the First Amendment, any attempt by the government to license journalists would never, hopefully, survive in this country because all the cliches about the press being the fourth branch of government and all of that. There are other countries, many of them, that do license journalists. And they make you, and it's usually the government that decides what's responsible behavior and what's not. So when I would bring up this notion, you don't want the government having enforcement power on standards of they said, well, what about another NGO or a sort of a quasi-governmental or a private institution that would have the ability to go out and punish these journalists? Well, as an American journalist, I don't like that either. And it's always kind of an odd notion to me that other journalists want some other official body deciding whether or not they are behaving ethically. Now, in some countries where you have benevolent regulators, it's not that big of a deal. But when I mentioned I have foreign journalists who come in on these State Department-sponsored trips and we'll sit down, criminal libel is a huge thing virtually everywhere in the world except the United States. It is theoretically possible in some states to prosecute someone for criminal libel, but I think in the 10 years I've been in this job, I can think of maybe 6 or 7 times nationwide where a state has, some local prosecutor has gone after a reporter. But there are a lot of reporters out there that are punished, and it's not necessarily because they published a falsehood. Criminal libel in many countries in the world can happen if you insult a politician. I often get this question, can you insult politicians in the United States? And I'm like, heck yes, it's expected. It's the American way. Of course you can. Are you going to be published for writing a column that some public official will find insulting? No, you're not, and I think that's a good thing. But in Latin America in particular, they have this body of laws called desacato laws, where you are not allowed to publish anything critical about anyone in power, even if it is true. So, that's another example of why, American reporters need to do a better job of recognizing how good they have it. They really do.
No, good job.
We have had a share of sedition laws, 1798,
Right.
and then we had them in World War I, starting at the state level. Amazingly, states would have their own sedition laws. We had one in 1940 with the Smith Act. Unfortunately, we haven't had one since, where you could go to prison for 20 years by saying something critical of the president or any member of Congress or the court. And we haven't had that for a while. So maybe we've grown up. In the back, please.
Is Reporters Without Borders active in Chechnya? We don't have any correspondent right there because it's too dangerous. We have our researcher from the European part, like East Europe. She went there twice in the last 2 years because it's really a region that we are focusing on, really. And we are trying to have an office, a representative in Moscow to be at least on the territory. But as you can expect it's really hard for us to open an office there.
It is very hard for reporters anywhere, even in Russia, to get into Chechnya. It's almost impossible. I was mentioning there were all these public officials from around the world at the Vienna conference. There was a young man, Alexander, and he works for an online publication in Moscow. And he had been trying to get permission for a very long time to get into Chechnya. The fellow there were 2 dignitaries from Russia, and one of them had the ability to actually grant these reporters visas. This Alexander had been trying for a couple of years to get this guy's attention, and the next thing you know, this guy's in the room with him. And it was interesting to watch this young man go after him, saying, you know, when am I going to get the, and you have to go through special security training, and this guy was explaining in front of all of us that, well, it's so dangerous, they're just trying to protect the journalists from being killed once they go over there, and that's the official line from the Russians. It was fascinating, and I remember saying to a couple of my American counterparts, the next story I hear about Alexander, it's going to be his obituary, because he's you know, he was taking incredible risks, just even attempting to get in there to report.
Did Russia sign the Vienna document?
Countries were not signatories. I'm trying to see if anyone specifically in Independent Journalism Center out of Moldova. No, I don't think anyone in Russia. No, it doesn't look like it.
So this was signed by individuals from different countries?
It was signed largely by NGOs, the International Press Institute, the Media Foundation for West Africa, Media Watch Bangladesh, the Pakistan Press Foundation, Canadian Journalists for Free Expression, groups like that.
Other questions, please? Ruth, you always have questions. Anyone else?
Yeah.
I think this was a great speech and everything, but I wish there had been a devil's advocate somewhere that brought out the other side. I mean, there are people who might say that this country doesn't protect security enough. This country doesn't do enough to protect the privacy of someone about whom the press is writing things that are none of their business. Are you aware of such opinions, and where do you think you stand in relationship to them?
Well, I certainly run into those people every day. And I recognize that those are sincerely held beliefs by people I respect greatly. And I recognize that national security in particular, there is a natural tension, and there should be. I used to explain it this way. In times of great national stress, like the attacks of 9/11, we all react immediately and instinctively. It is the immediate instinct of the media and a lot of other institutions to gather as much information as it possibly can. It is the instinct of the executive branch in particular to go so far in trying to institute security that they will almost inevitably go too far. They will bring Congress along with them, which is what I think happened. They will bring the courts along with them. And it takes a period of time, I think it was about 6 years, before those folks were saying, yeah, we understand why you were so concerned, but they start pushing back, and they start pushing back. And I think it's part of the beauty of the American system is they push back to some middle ground, some place where we can really get along and understand, and I think we are almost back to that point right now, where both the need for people to have information and the need to protect national security are coexisting in some sort of equilibrium. Because I got to tell you, right after 9/11, billions of pieces of information that we used to have access to vanished virtually overnight. The privacy issue is also complicated, but in a different way. I personally think that there are vast protections for personal privacy in this country. I would be among the first to recognize that there is a need to protect certain pieces of information for identity theft purposes. And we've actually, at the Reporters Committee, worked with a lot of organizations and a lot of government entities to make sure that in an effort to protect people from identity theft, Not everything that used to be public is thrown out. I mean, you talk to the genealogists. There are efforts in some states to close down all birth and death records. Well, there are very good reasons why we traditionally have made those pieces of information public. There were efforts to shut down property records. Well, I'm sorry, our entire property law system in this country would shut down if we no longer made it possible to find out who owned a certain piece of property. At the same time, do some media entities report too much, more than you would ever want to know, and exceed the bounds of good taste? You bet they do. And quite honestly, the best, I believe, the best way to combat that is market forces. Don't read that stuff.
Mm-hmm.
Force them out of business. If there weren't a market for it, they wouldn't sell it. You know, sorry.
Isn't it quite often the opposite? That people, it's more marketable to publish things that are kind of scandalous instead of
You know,
respect?
I'm not
Good journalism is read by a smaller segment of
Mhm.
society.
Mhm.
I'm sorry to say.
It is.
My
I agree with you.
perception.
That you're absolutely correct. And it's one of the frustrating things about being a journalist these days. I have to also tell you, though, market forces are playing a force in that, because those gossipy stories, those are the cheap ones to get.
Mm.
That's cheap. You can always find somebody to give you information on that. You can pull a public record about Tiger Woods being, well, no, actually you really can't, because they didn't arrest him. But, you know, you can do that kind of reporting. These days, when local newspapers, and this is the subject of a totally different panel discussion, but your local media, and particularly your large-size media daily newspapers that we have relied on to do a lot of digging over the years, can't afford to do it anymore. But those gossipy stories are extremely cheap to collect, and that's why you're seeing a lot more of it.
With the internet and accessibility of news on the internet, it seems sometimes this reduces the level of articles, and the younger generation, I'm talking like a mom, I'm afraid I'm reading less
Yeah, I know.
than the extensive stories that were reported in traditional paper.
I think we've got a serious problem in this country with a very lazy electorate, and it frightens me.
One of the problems I think a lot of people have with the press is there's a little feeling that press is a little sanctimonious. And
True.
that type of blaming the electorate for, which is often laziness on the part of journalists, I think doesn't sit well with a lot of people. And I think you probably felt in this audience there is some, tension, I think, even though you both seem like very nice people and reasonable, but there is a tension between journalists today and the public. I think partly starting with what this gentleman was referring to, which is the politicization of the media, has alienated many people. And then also, sometimes you take an attitude that is of self-importance. For instance, you mentioned early on, you said something about terrorism grows in darkness. And
That's the resolution, right.
And I thought that was sort of funny because, ironic, because I was coming in this morning and all I heard on the radio was the story about the 5 young gentlemen from Arlington who have just been arrested in Pakistan. There's a similar case in Canada a couple of years ago of homegrown terrorists, young gentlemen.
And Somalis from America.
Grown up under the American system. They've had all the advantages of a free press, and yet they seem to be attracted to jihadism.
Steve, we got to vacate this room. That's another.
I guess I should quit.
We have to stop.
I appreciate your comments.
And this is a very important day for us, and very honored and privileged to have 2 wonderful speakers. Because if you could help me thank them for it.
This has been a presentation of the Library of Congress. Visit us at loc.gov.